Can I welcome everyone to the 23rd meeting in 2019 of the Delegated Powers and Law Reform Committee. The first item of business is to propose that we take items 6 and 7 in private. Do we agree to that? Okay. So the second item is consideration of SSIs laid under the European Union Withdrawal Act 2018. We're considering the scrutiny procedure under which it's been laid and the categorisation applied by the Scottish Government. The management of extractive waste EU exit Scotland miscellaneous amendments regulations 2019 SSI 2019-273 has been laid under the negative procedure and has been categorised as of low significance. The regulations make minor and technical changes to the management of extractive waste Scotland regulations 2010. The amendments seek to ensure that references within the regulations are up to date and that deficiencies arising from the withdrawal of the UK from the EU are addressed. Our advisers indicate the scrutiny procedure and categorisation could be appropriate. So are we content that the appropriate scrutiny procedure and categorisation has been applied to the instrument? Okay. Next is the Town and Country Planning and Electricity Works EU Exit Scotland Miscellaneous Amendment Regulations 2019 SSI 2019-274. That's been laid under the negative procedure. It's been categorised as of low significance. The instrument amends the coming into force date of and makes 3 minor amendments to the Town and Country Planning and Electricity Works EU Exit Scotland Amendment Regulations 2019 to correct some minor drafting errors which were identified by this committee. Our advisers indicate the scrutiny procedure and categorisation could be appropriate. So are we happy with that? Okay. And the next item is instruments subject to negative procedure. No points have been raised on SSI 2019-271 or on either of the instruments the committee considered under the previous item, SSIs 2019-273 and 274. Is the committee content with these instruments? Okay, lovely. Agenda item 4 is we're looking at the Representation of the People Act 1983 Remedial Scotland Order 2019. And we've got before us Michael Russell, Cabinet Secretary for Government Business and Constitutional Relations. He's going to give evidence on the Representation of the People Act as well as the Referendum Scotland Bill. But we'll look at the remedial order first. Mr Russell's accompanied by 3 government officials. Penny Curtis, the Head of Elections and Freedom of Information Division. Ian Hockenhull, Bill Team Leader, Elections Team. And Ewan McCaig, who is a solicitor. So I welcome you all. Cabinet Secretary, I understand you've got some opening remarks.
Thank you, Convener, and thank you for the opportunity to discuss the remedial order under the Convention Rights legislation that enabled limited prisoner voting in the Shetland Islands by-election. I'm grateful to you for your letter setting out a number of questions in relation to the order, and I'm happy to address them. I'd also like to put on record the fact that I'm sorry I was unable to provide advance warning of our intention to make the order, but I did, as you know, write to you on the day that the order was made, giving you information about it on the 1st of August. The reason, of course, was the timescale and the nature of the recess. The official notice of the by-election was given on the 15th of July, which meant that there was a very limited period available in order to arrange for limited prisoner voting at the election. With the election registration deadline set at midnight on Tuesday the 13th of August, it was imperative for any action that we took to be made as quickly as possible in order to allow any qualifying prisoners to register. All consideration occurred during recess, which limited the scope for engagement. With the Scottish Elections Franchise and Representation Bill already before Parliament, I decided to apply the scheme under that bill to enfranchise prisoners serving sentences of 12 months or less to the by-election. I have been very clear, as have all my colleagues, that the blanket ban on prisoner voting is not fit for purpose. That's also the legal situation with the ECHR. It is not compliant and compatible with the ECHR as it applies to Scottish Parliament elections. Under those circumstances, in my view, it wasn't optional. It was essential to ensure ECHR compliance in relation to the by-election. And I'm very happy to go into the detail of that, why the decision was made and how it operated.
Okay, thanks very much for that. So is it your view that this was the only course of action you could have taken?
No, I think there were, convener, three possible courses of action. One was to do nothing, but in my view, I have to say very strongly, that would have put the Scottish Parliament in and the election in breach of the convention, and I think that was completely unacceptable. The second one was to have emergency legislation, and I simply say to you, convener, that the view that members might have taken that I wish to recall Parliament on or around the 1st of August in order to have an emergency bill on this matter. Let me put it this way, members might not have been sympathetic to that actually taking place. So the third option was to find some form of secondary legislation which we could undertake. Obviously, we could have worked under the Human Rights Act, but it seemed to me, and I have to say I think this is probably incontrovertible, that the convention mechanism was tailor-made for these circumstances. This is where a breach of convention, the convention has to be rectified as a matter of urgency. It has been used in this Parliament before, I think in 2003 certainly, for a sexual offences issue. So I just felt that that was the right way to do it, and that's why we used that legislation. Clearly we can debate whether it was, but I'm not entirely sure any of us would have been happy with a recall.
You may well be right. So, I mean, obviously, you've referenced the letter that you sent to myself, and therefore the whole committee, which was, I think, actually arrived the day before the order came into force.
Yes, it was sent the day the order was signed.
Yes.
On the 1st of August.
So, is it are you saying that it was just not possible to have given us any more notice that this was coming?
I think the issue there was, during the recess, coming to the right decision and implementing the right decision in a very short period of time. The date of this by-election, the calling of by-election, was not ours or yours to give. It was brought about very quickly. We had to decide on the right order and how to move forward in that. We didn't take this lightly, so there were decisions to be made about what the right route was. Once we had identified and decided upon the right route, and that was done, then I thought it was important to tell you that it was done. This is an act of government, and then the scrutiny therefore follows thereafter. Normally, and I'm sure we'll come to this, there would be a immediate scrutiny of it, but in this occasion it was not possible to do so.
So it wasn't possible to give us any more
no,
time, even a day or two?
No, I think we told you when we could tell you, and we told you then the day before it came into effect. Yeah. And secondary legislation was what we felt we had to do.
Okay. This all really stems from the Hurst case, which involved the UK government, which looked at the compatibility of not allowing prisoners to vote with ECHR. You'll be aware, I presume you're aware, that the UK government came to an agreement with Europe, which wasn't exactly what you've done, but the agreement was prisoners on remand could vote, prisoners committed to prison for contempt of court could vote, prisoners committed to prison for default in paying fines could vote. Some prisoners released on temporary licence could vote, and prisoners released on home detention curfew could vote. I think there's one more. Prisoners will be notified of their disenfranchisement at the time of sentence. And the Committee of Ministers accepted that and said that was enough to be compliant with ECHR. But you appear to have gone beyond that, and that is despite the fact that we have a bill in front of this Parliament which hasn't been dealt with. Why did you go beyond that when you didn't appear to need to?
Well, I should just put this in context. The decision of the UK has not yet been tested, and the expectation, I understand, is that it will be tested. It is not entirely, in fact, it's hardly proportionate in terms of the nature of the crime. There are people, for example, on temporary release who could vote whose crimes were very much more serious than anybody who is enfranchised as a result of our proposals. So my view is that that is not a safe way to proceed and would result in, inevitably, in challenges. And therefore, my job has to be to decide on the option that we feel will be safest. It's perhaps interesting to note that our 12-month proposal, which is in the bill, and the reason that the order has it is exactly because it is in the bill. I didn't want to go an inch or iota further than the proposal that was made and didn't. It is interesting to note, however, for example, in Wales, that the proposal in Wales is to be 4 years for sentences. So there's a range of views about this. Now, these are issues that will be tested in the passage of the franchise bill. But in my view, all I should rightly do, if I had to, as I felt I had to make a change on this occasion for the by-election, was to mirror what the government's proposal would be in the legislation that comes, not to go any further, but certainly not to resile from it into areas which, broadly, I feel would be unsafe.
I'm just trying to get to whether you needed to go as far as you did, because the Committee of Ministers last year, in fact a year ago, said that those UK proposals were, quotes, an effective package to ensure compatibility with the Hearst judgment. That's what they said. So, is that not? Could you not have left it at that?
No, I can't. Obviously, I won't talk about legal advice, but clearly there will be a view that the Committee of Ministers' view would not be the same as the Court's view, particularly the European Court's view, when that was tested. And I think the obligation upon me, convener, was to find what I felt was the safest way to do this without going further than any proposals that I had already made. Now, as the bill in front of the Parliament has a 12-month proposal, which is not uncontroversial, there are people in this room who would wish to go further. Given that it was in the legislation, that struck me as the right and safest thing to do. So I mirrored the legislation. I also made sure, by the mechanism we used, that it was time limited, so that in actual fact this order will lapse, and that was a very important consideration from me, that I was not preempting the decision of the Parliament, except insofar that to observe the convention, something had to be done for the Shetland by-election.
Okay. Well, thanks for that. We've got other members who want to come in. Stuart.
Thank you. Good morning, Cabinet Secretary. You mentioned that the bill that's in front of the Parliament at the moment, and if there were to be another by-election before the bill passes through the parliamentary process, would you bring forward another remedial order?
I think that would entirely depend upon the timing of the by-election. I hope there isn't another by-election, and I hope that we have the opportunity to consider this bill and to resolve what the mind of the Parliament is on this, although the law is entirely clear we have to do something, But I hope that doesn't happen. The question would be the timing of that. My absolutely full intention would be to make sure that there was full scrutiny of any decision we took in the normal time frame. But if another by-election were to take place in the recess, then we may have to apply the same remedy, given that there isn't to be as far as we know, unless the Parliament is prorogued, there isn't to be another 9-week recess, between now and next summer, and the bill will be through by next summer. I think it's likely that that wouldn't be the case.
If another remedial order actually were to be required at some point in the future, what could the Scottish Government do differently to ensure that parliamentary scrutiny of the exercise of this delegated power before that scrutiny becomes redundant?
Well, I think we've been very clear that we welcome scrutiny. My letter to the committee said I wanted to have this discussion. I responded to the letter that the convener back to me. We're not in any sense saying that we don't want scrutiny on this. The sheer mechanics of it is if you have three options, do nothing, have a piece of emergency legislation, or do this, and you take this, then, quite clearly there is a process of scrutiny for it. The fact that any order will come into effect within a timescale, and that the timescale of these orders is 60 days, which does not include recess periods, is simply a fact of the matter. But, I want scrutiny. That's why I welcome this discussion here, and we would endeavour to avoid these circumstances where we can, but it was physically impossible to avoid these circumstances given the timetable of the by-election, again, not in our gift, not in this committee's gift, and the nature of the problem we had to resolve.
And just finally, from me, Cabinet Secretary, obviously the fact that the timing certainly wasn't helpful for scrutiny for anybody. But going forward, if a by-election, another one were to take place, but the timing of it were to be different, if it weren't to be in a recess period, what other options would be available to you if the bill hasn't passed its process?
Well, the options would be broadly the same, but as the bill is in process, one would hope that the time existed for the bill to be completed. This bill requires supermajority, of course. There is that issue. But I would want this bill to be completed before there was any such question, and we would judge that accordingly.
Okay. Thank you.
Okay. Mary?
Convener, and good morning, Cabinet Secretary. The by-election to which the order relates will have passed by the end of the 60-day period for observations. Why wait to the end of the period before revoking the order?
I have no option. The order has to run until it is revoked. I can't do anything about that. No, it's just there. I mean, it's not doing any harm, but equally, I can't revoke the order now. It has to run its 60-day period for comment.
Okay. So, comments that are made during that 60-day period, what regard is given to those observations?
I will give regard to any such comment that's been received. We've received, I understand, none as yet. But if there are comments received, then we will obviously look at them. It's difficult to know what those comments would be. This committee is quite likely rehearsing, I think, the key issues which arise. But there could be other comments. I can't imagine what they are, but they are. We'll look at them, of course. I'm obliged to do so under the order.
Any comments made would feed into, if you were in this situation again, would feed into the process you would take?
If somebody has a bright idea how we can avoid this, I can't see what it is myself, but if there's a bright idea how to avoid this, of course, I welcome all good ideas. But we haven't had one yet, but, I'm eye-hoping, as they say.
Still time.
Indeed.
Thank you. Thank you, Convener.
Okay. Just out of interest, how many prisoners were actually affected by this?
There is obviously, it would be wrong to inquire into the individual voter, and we do not do so. So in those circumstances, I cannot tell you. Our estimate was up to 5 individuals might be eligible to vote, but we do not know if they did vote, because that would clearly be the wrong thing to ask.
Yeah, and you might be able to identify them.
Exactly, so I don't know. But it's very difficult to tell. I mean, the assessment of who is eligible to vote would be prisoners who have postal codes within the Shetland area. There could have been others who were normally resident in Shetland but gave another address at the time of conviction. There may be some who had a Shetland postcode and address but who were not resident in Shetland. So we do not know. The estimate from the Scottish Prison Service was up to 5. We don't know if they have voted.
Okay. Tom?
Just one very quick question. Had you chosen to proceed by recalling Parliament for emergency legislation, would that legislation have been subject to the supermajority requirement? Yes. It would have, so it wouldn't have just been a quick question of trying to get the Parliament quota. It would have been having to have enough members back for a supermajority. I
think I'm right in that. It would have been, yes, no, it's an alteration to the franchise which would have required a supermajority. So that would have put an additional hurdle into the system.
And the supermajority is not a supermajority of members present, but a supermajority of all members.
Yeah, it is a supermajority. There seems to be unanimity amongst us, which is beginning to look like a quiz team. But there seems to be unanimity on this matter that it would require all members present, which would have been difficult to achieve. Yeah. I mean, some people may have been sunning themselves in Lanzarote or on study tours of the Arctic, but wherever they are, it would have been difficult to achieve.
Thank you. Were you in either place?
No.
Right. Okay, on that happy note, I think we'll end that session. So I'll suspend the meeting briefly so we can get a change of officials. So we'll move on to agenda item 5, which is the Referendums Scotland Bill. We've still got Michael Russell with us, we've still got Penny Curtis with us, and we've got a couple of new officials, Rebecca White, Referendums Bill Team Leader, and Graham Fisher, Solicitor. So welcome to you. And Cabinet Secretary, you've got an opening statement on this one.
Thank you, and thank you for looking at the delegated powers created by the Referendum Scotland Bill. I know the independence debate and this bill are potentially linked, but let me start by recalling the purpose of the bill, which is to put in place a standing framework of referendum rules which apply to different referendums held across Scotland. For the responses to the committee's call for evidence, it's obvious that a wide range of bodies, administrators, legal commentators and academics all support the general principles of the bill, but they may not agree on the individual details. And I make it clear at the outset that I'm very willing and happy to debate those individual details. I don't regard them as being set in stone. You know, I've been in front of this committee before on bills, and my view is always the bills can be improved and developed, and I'm sure that will happen. Our objective, as with all of our work to update the electoral law, is to ensure that the bill reflects best practice and puts the interest of the voter first. Delegated powers are considered appropriate in a number of places in the bill to ensure that the framework is operative and to future-proof the framework against wider changes in electoral law. In framing the provisions in the bill, the government has been very mindful of striking an appropriate balance between the use of primary legislation and the use of delegated powers. Where the government has decided that policy objectives are most appropriately met through the use of delegated powers, we of course want to ensure that Parliament has the necessary evidence from and engagement with the government to give informed and constructive scrutiny of the proposals. I'm aware that you wrote to the Scottish Government with specific questions on a number of proposed delegated powers, and you have received a detailed response which you will have in front of you. I hope that has been helpful in your considerations. I'm keen to hear further from members to see where I can build on that, work with the committee and the Parliament in addressing ongoing concerns as I can. I want, however, to emphasise my overarching intention to ensure that the bill reflects best practice and is in the interests of voters and is helpful to electoral administrators. I continue to follow the evidence provided to the Finance and Constitution Committee with great interest. I am open to alternative approaches to the bill where these would more effectively facilitate the aims of the bill. We're not precious about the details. I want to come up with the best solutions available, and I'm happy in that spirit to answer any questions you have.
Okay, thanks for that. So if we look at, first of all, this idea that any future referendums will be dealt with by subordinate legislation, which is completely new. Why have you chosen to go down that route?
I think I've read the evidence that the Finance and Constitution Committee have recently had with some interest, and I think some people miss exactly what we're doing here, and it's quite important just to stress that at the outset. We're not trying to replicate the Westminster legislation, which is 19 years old and which has served reasonably well. Our approach is a different approach, and the requirement for that is actually shown by the EU referendum bill. The EU referendum bill in the UK was, I think, 60 pages long. It was massive. And what it did was it brought all the detail of the referendum into the Parliament in a piece of primary legislation. And it plugged into a much smaller and more vague, frankly, Westminster piece of electoral legislation. We're doing the opposite. We're providing a detailed framework for each and every referendum where there to be a number of referenda. And what we're then doing, because that's there, what we're then doing is bringing the detail of the of the individual referendum to plug into that. And those details are comparatively simple. They are the nature of the question. They are issues to do with the immediate campaign. They are issues to do with possibly the franchise. So it's a sort of reverse of the Westminster situation. Now, I'm entirely open to discussion as to whether secondary affirmative, super affirmative, or primary legislation is required. But on the understanding that that's what we're trying to do. We're trying to make sure that there is a standing set of arrangements, a framework for referenda, which is very detailed. And necessarily detailed. It can also be dynamic. Because the other issue about electoral law, which we have discovered, I think, in recent times, is electoral law needs to be dynamic. What we have seen south of the border should persuade us that there needs to be a constant process of uprating and changing, a franchise, for example. So I think if we understand the bill in that way, then our approach becomes clearer. Now, that's not to say that that approach is set in stone, but it is important to understand what we're trying to do.
What do you mean by dynamic?
I mean that it is possible to incorporate change in best practice into that legislation without constantly returning to primary legislation. I mean, when you have a conversation with the Electoral Commission, it is quite clear that they are constantly reviewing, rightly so, how elections should be run, how referenda should be done, how regulations exist. We've got in front of the Parliament at this present moment 3, possibly 4 pieces of legislation that relate to legislation. I say possibly 4 because we've got the continuity bill, which may or may not. But we've got 3 substantial pieces of legislation on elections. We've got the referendum bill, we've got the franchise bill, and we've got a broader bill on the details of elections. Now, you will be involved in all of them. I think it is important to find a way that best practice can continue to inform those. And that's not without scrutiny, because nobody is saying it shouldn't have scrutiny. But we should find the process that best matches that ambition and the way in which we're approaching this issue.
Right. You're well aware this committee doesn't deal with policy matters, so we're keen to avoid any discussion about what this may or may not be for. Say it's for independence. It could be for any kind of referendum, but it could be a constitutional matter, which is obviously extremely important. There's been a number of submissions, which you'll have seen, to the lead committee. But I just want to read out some of the comments, and you can respond to them on the record. So we have the Law Society of Scotland saying we have reservations about the use of subordinate legislation for the most important questions relating to the Constitution. Such issues require full and proper scrutiny, which subordinate legislation does not provide. And that essentially sums up what they're saying about this issue. And then we've got comments from Dr Allen Renick. You'll have seen those. I'm just going to read it to you. He goes on. He's talking about the regulation-making powers. He said ministers will be empowered to call a referendum on any subject within the competence of the Scottish Parliament via secondary legislation. Ministers' powers to specify the referendum period would be very broad. Ministers would be given very wide powers to amend the Act by regulations. It would be highly desirable, he says, to limit each of these powers. And he then goes on to say that he cannot find any well-functioning parliamentary democracy that gives ministers blanket authority to call a referendum by secondary legislation, nor can I, because I did my own research. So there are concerns about using secondary legislation for a referendum, particularly if it is a constitutional matter. You said in your opening statement, Anne, earlier that you're flexible on this, so I guess you can appreciate where these concerns are coming from. I just wonder if you could respond to them. Yes,
of course. I mean, I've read the evidence. I've also seen the positive support for the bill that comes. Allen Renick himself said the bill should be welcomed. Its objective of creating a legislative framework for future referendums is sound, would allow Scotland to meet international best practice. What we are talking about here is the detail of how we go about doing so. And the detail, rightly for your committee, of course, about delegated powers. I think if there is a full understanding, and I would want to talk to Allen Renick about this. Unfortunately, I didn't get the chance at the weekend. I was at the same conference in Cambridge with him, and I would have wanted to do so. If we had had a conversation about the nature of putting in place the framework and then adding to it, then the question becomes a level of scrutiny for that addition. Now, I entirely accept that. So what we are talking about here is a level of scrutiny for that addition. It may not be a blanket level of scrutiny that applies in every circumstance. That is something I think we should debate. For example, if you were to hold a referendum on issues that were referred to, let me take an example that's not necessarily constitutional, issues that were referred to the Scottish Parliament by a citizens' assembly. Would you have a different procedure in terms of how that operated than you would have, for example, in New Zealand they can hold referenda by post, And those postal referenda have, for example, included one on the selling off of a minority stake in the airline. And that was something they put to people in a referendum. So not all referenda are the same. Now, I'm not saying we're going to take either of those routes, but not all referenda are the same. So I think where I agree with Allen Renick is, there is no exact correspondence between legislatures, but the level of scrutiny is something that we need to get right. So would it be possible, for example, to introduce an idea into the bill that there was a different level of scrutiny for different types of referenda and originating in different ways? Would a Section 30 referendum on any subject, because Section 30 referenda can be on any subject, be of a different order in terms of how it would be approached in terms of scrutiny than something on the selling off of state assets? So I think that is a debate we need to have. I've put forward a proposal here. That proposal should be debated. I don't think we're going to wind down the level of scrutiny. So is the scrutiny to be affirmative, super affirmative, or primary? That would be the scope of that debate. And I think that's a debate we should have.
And do you think that can be reflected in this bill then?
Yes, I think it's perfectly possible to reflect that in the bill should the Parliament wish to do so. I think if you say there shouldn't be secondary legislation, it should always be primary, you're setting a pretty high bar for things that may not require that. So I think then you would say, how do we deal with that? And I'm very happy to have that discussion. There may be good ideas about that lying in a lot of different places.
Okay. So before I bring other members in, just to sort of pin this one down, I mean, it's clearly there are different types of referendums. I mean, if you were to have a referendum on how often people should have their bins emptied, that's completely different to a referendum under a Section 30 order. So could this legislation, could this bill reflect those differences? I think you said yes, but it doesn't at the moment.
I think it does in the sense that, convener, this is about, and we're talking about exactly the same thing here, a structure how to hold referenda, whether it is about bin collection or whether it is about Section 30 order, then basic legal structure is the same. What we're talking about here is how it is initiated and scrutinised in terms of the question, the specific nature of the referendum. This is the referendum as a general principle. This is a specific nature of each referendum. Now, I think that is clear from the bill because we're putting the framework together. If there is required for a variation on the way in which scrutiny takes place according to the nature of the referendum, that is something I'm very happy to discuss.
Stuart.
Thank you. Cabinet Secretary, just following on from Graham Simpson's questions, has the Scottish Government received many requests to have referendums, notwithstanding another referendum on Scotland's constitutional future?
I'm not aware that we have. I mean, I do hear lots of people talking about holding referendums, but I'm not aware we've had a formal request for any. When you look at, as I was saying to the convener, he's been doing his research, he will know this too. When you look at how referenda are used, they're used in very different ways. And there's an interesting, sometimes interchange between referenda and citizens' assemblies and direct democracy. I think it is in Oregon that what a citizens' assembly does is produce the basic A4 sheet, which voters look at and see the argument when they go into the booth to vote in a referendum. So there's an interchange there. So I'm unaware of any specific requests, and I was absolutely determined before I came in here that I wasn't going to give examples, because then, they'll be reporting that I wanted a referendum. It was a convener who wants a referendum on bins being emptied, not me. I just make that for the record. So, but, people may wish one, and I don't hold the view that your referenda are discredited, I think people may want one, and if they do want one, it is absolutely right that we have the structure in place.
The reason I posed the question was just to see if there had been a number of requests, if that had actually helped shape your view of how the bill was actually drafted.
Well, the bill has been shaped by many people and many voices. The Electoral Commission, a range of stakeholders. This hasn't come from nowhere. And of course, we constantly talk to people like the Electoral Commission and to administrators. One of my jobs, one of Rebecca's jobs, one of Penny's jobs is to talk to administrators all the time. So it's shaped by best practice, but it can always get better. One of the things I am often heartened by in my interaction with administrators particularly is interest in constantly improving what we have so that it serves citizens.
Certainly, in terms of you mentioned earlier on regarding the correspondence between the committee and yourself, and in your reply to the committee's written questions, you indicated that the need for certainty of timing requires referendums to be established by subordinate legislation. Can you expand further on the need for certainty of timing and why this could not be achieved with primary legislation, for example, using an expedited bill procedure?
I think this relates to the basic point I keep making, and I just want to go back to it. You have the framework there. You know how it's going to operate. And then you have the specific arrangements and circumstances for a specific question, specific referendum. And that will alter. If the issue has been rehearsed again and again and people are, want to get on and make a decision, you can make a decision about timescale. Whether it is quick or slow, you've got the opportunity to do so. There's a difference between that and the technical timescale in which you decide upon, what's the procedure in which you decide upon a legal organisation, what's the decision, the Electoral Commission is involved in these processes. So those are issues that need to be tied down, but you can be flexible about the actual nature of it. Nobody would want to have, I go back to this New Zealand referendum on selling off state assets. Nobody would want that to go on for 10 weeks. There's a question, send it out, see what the answer is, end of story. So I think it's that flexibility for the particular referendum plugged into the arrangements for every referendum that make this bill an important and fairly unique piece of legislation.
Okay. And finally, can you outline the expected time frame to bring forward a referendum after the Parliament has considered regulations under Section 1?
The recommendation of, what is the recommendation?
The Electoral Commission recommends a 10-week referendum period.
Yeah. Well, I think we would be flexible on that as on all other matters. It would depend upon what could be done and how it could be done. The primary movers in this would be the administrators. You would not hold a referendum unless you were certain that administrators could deliver it within the time period you talked about. Elections are like that. The nature of an election is you have a timetable. It can be truncated or expanded, but you would want to make sure it could be delivered, and often the circumstances of that depend upon, for example, the time of year.
Okay, thank you.
Just on the question of timing, just to follow on from Stuart McMillan's questions, is there not a risk if we're just always using subordinate legislation, that could be used by a government, any government, to force through, rush through what could be pretty substantial?
But it will be scrutinised. I am in no sense arguing that there should be no scrutiny. The level of scrutiny within that is the issue, but it will be scrutinised. It's not. There's nothing in this that says the government can just say it. There is a process of scrutiny that takes place. There's also another important consideration. I would be very surprised, indeed, if in a controversial referendum subject, there was not a very long period of discussion and debate upon the subject. And that's the experience that we've had everywhere. If you call into evidence the referendum in Ireland on abortion, it was a culmination of many years of discussion and debate. And, of course, the Citizens' Assembly process there was the one that unlocked it and provided the opportunity. But then there was a parliamentary committee that looked at the recommendations of the Citizens' Assembly, and then they put into place the arrangements for a referendum, within the way that the Irish state does those things. So I think these things are likely to be at the centre of public attention and scrutiny. A government may attempt things. It's a different question of whether they get away with it.
Governments always attempt things. Mary.
Convener, I want to stay on the theme of scrutiny, because you said in your opening remarks that this bill provides a legal framework for referendums, for any type of referendums, and you accepted there could be a number of different types of referendums. And the conveners very helpfully suggested we should have a referendum on bin collections. So No, well, so that sits at one end, bin collections, and we could have a referendum on a constitutional issue at the other. But you also accept that you would need different types of scrutiny and discussion for each of those types, wherever they may sit in that broad scale of referendum. So should this bill not be clearer in the type of consultation, discussion and scrutiny that should be attached to the different referendums that will sit within this legal framework?
I've introduced that as an idea because I think that is an idea that would move from the position that we have taken in the original draft to some of the comment that has been made upon it, right? So I think that's an entirely reasonable proposition to put forward. I think that would be a question then of debate at the second stage of the bill as to how that should work. I'm indicating I'm not resistant to that idea in any way, but I think that we need to do, for example, I think you need very clear criteria to apply, and I think some thinking needs to be done about those clear criteria you would apply, without dissing the idea of a referendum on bin opening. You would have a different set of criteria. So, I mean, I'm indicating I'm not in any sense resistant to that, but I'd want to have a discussion about how it looked.
Because currently it's almost as if this is a one-size-fits-all piece of legislation.
We're not trying to do that. That's why
Yeah.
the secondary legislation can alter, a range of things. The question is the level of scrutiny that takes place when you are deciding those things, whether that scrutiny should be one size fits all. And I entirely agree with you. But, if there's an argument that it shouldn't be one size fits all, then we move on to saying what it should look like. How should it apply? I've indicated Section 30 orders. I've indicated Citizens' Assembly. There may be other criteria. If you were to, for example, if you were to take the issue of end-of-life issues, how would you address those? Because they're a very different type of moral question, as the abortion issue was, which might require very different views. You might say in those circumstances it would be important to have primary legislation because the very act of asking those questions would be controversial. Some people would not believe that those questions should be asked. So there might be an issue in there where you would want to say, is there a category of these things to which conscience perhaps applies, which you would need to think through very carefully. And I think it's useful that we're having that discussion because it fleshes out what appears to be a pretty level playing field. There are in actual fact huge differences in this.
And if there are arguments against it being a one-size-fits-all and there will be consultation and feedback that will feed into that argument, will Parliament play a full role at the beginning of that process?
Well, I would hope so. I mean, I would hope so. I would have thought, if you have the framework agreed, and the framework should be pretty non-controversial about how a referendum is run and what governs it. If you have the framework agreed, then the level of scrutiny on that will depend upon, will dictate the level of parliamentary involvement. If it is an affirmative resolution, then there will be one level. If it is super affirmative, there will be another level. If it was primary legislation, we know the legislative process, so we know how that would drive through. There would be the question of the general principles of a bill. There would be the question of the detailed arrangements, and then there would be a stage 3 process. So that would dictate how Parliament was involved. But crucially, at all levels of scrutiny, Parliament would be involved. We're not talking about a process that does not have parliamentary involvement, and it would be active involvement because we're not talking about a negative procedure.
When you say Parliament would be involved, I'd be keen to hear a bit more detail about what you see that looking like. Would that be full debates? Would it be the laying of instruments? What exactly do you see that being?
All of those levels of scrutiny have their own automatic involvement of the Parliament. Affirmative, super affirmative, and primary legislation all have their own existing level of now. It's not likely, you know Parliament very well, it's not likely that any of those things would happen without substantial debate in Parliament beforehand. If an issue is one that gets to the stage of a referendum, even the bins, wherever they are, there will have been, might start off with a members' debate, there will have been perhaps an opposition debate, there will certainly possibly have been a government reaction to a committee report. All of those things will take place. What we're talking about here in the legislation is the level of scrutiny that would take place at the conclusion of that process, when a referendum was recommended or proposed, and how that scrutiny works.
And the bill currently provides for the affirmative procedure to apply to the regs under Section 1. Are you prepared to move that to super affirmative, given the discussions that have taken place here and I would imagine will be taking place in other committees?
I've indicated that from the very beginning, what I've said here. The proposal in here is for affirmative process. I have indicated I am very open to discussion on super affirmative or primary. I've indicated that my own view is that there needs to be criteria applied to that, and the concept of there being different types of referenda in this, in this second part of the process is one that we should discuss. So, I'm not indicating resistance to anything, but I am indicating if we're going to do that, we need to get our mind into what the criteria are and how they apply.
And my final question I would like to ask is around a statutory consultation requirement, because a statutory consultation requirement can often provide that far more detailed level of scrutiny. It can provide for far more feedback to be given. And is that something you would consider doing in relation to this?
It would depend on the level of scrutiny agreed. If the level of scrutiny has within it, as a legislative process has, an agreed level of consultation, yes, of course.
Referendum that this legislation applied to would depend on the type of
one thing leads to another. If you were to follow this route, and we're not there, but if you were to follow this route, one issue leads to another. If the type of referendum dictates the type of scrutiny dictates the type of consultation and who is involved in the process in that way. It's a fairly clear set of circumstances.
We'll just to summarise so far before we move on, the Cabinet Secretary has said that he's open to different levels of scrutiny depending on what the referendum issue would be. He's open to having that discussion. Alison Harris, you've got some questions.
Yes, good morning. I would like to ask you, the bill provides that the Electoral Commission should be consulted before regulations are laid under Section 1, but it does not provide that a draft of the regulations proposed should be shared with the Electoral Commission to inform that consultation. Why does the Scottish Government not consider it necessary to consult the Electoral Commission on the specific text of draft regulations?
This is one of those areas where perhaps the shorthand of what we do is lost on others. Drafts and drafting process of electoral law and legislation is done alongside and in conjunction with the Electoral Commission all the time. That's how it happens. So this is only the formal last stage. It is always done in consultation with the Election Commission. They will tell you exactly the same, and therefore we are simply reflecting what happens in life. There will be all those things happening. There are bound to be all those things happening. No legislation would arrive, electoral registration, without those things happening. But at the end of the day, there will also be a formal process, which is like belt and braces. We've done all that. It's all been done. Now let's have the formal discussion about it. It also makes the process much better because we can focus down onto the areas in which there is disagreement.
Okay, so trying to take that further forward then, would it not make sense then that, given that I think we would accept that, the Electoral Commission are really experts on matters, so would it not make sense that there should be no objections from the Commission on any kind of modifications?
No, they wouldn't want this either. They wouldn't want this either. There's this question, because there's a question later on that, we should always be bound by the Electoral Commission's rulings. The Electoral Commission does not wish to become political. The important thing here is to say, this is what the Electoral Commission says. The government should be absolutely transparent at that. When there is a report from the Election Commission, the government should have and will have an obligation to lay that report. It is then for members to decide whether the Election Commission's recommendation should be taken or not. 99 times out of 100, we would never get to those situations because there is the closest discussion. If we do get to that situation, it is important that there is in the end a decision by parliamentarians who are elected to make that decision. The Election Commission is not elected to make that decision. And to put them in that position would be something that neither they or anybody else would want.
Okay, so if I could just look at that slightly further, the evidence that was in front of the Finance and Constitution Committee, but even when you looked at the Law Society, I think I'm quoting when it said that they take the view that this approach provides the Commission from scrutinising the question in light of conditions as they are at the the time of any questions. So,
That's a different question.
okay.
Okay,
Right,
I
so you
mean-
don't think the two can
No,
coincide at any?
no, I'm happy to address the
Okay.
issue of the question specifically. If you do, you want me to?
Well, let's go back to the first one because. Okay, so you don't think the Electoral Commission want to be in that position, and am I correct in saying that?
And I don't think anybody would want to be in the position of saying the Electoral Commission makes the final decision on this and nobody has any say on it. The Parliament is passing legislation. The Parliament will make the decision. The recommendation of the Electoral Commission is absolutely essential and should be public, and the government should be absolutely clear, that it agrees or disagrees with it. But we shouldn't be in the position that that's just a final say.
Okay, right. I'll go on to my next question then. I'm confusing the two for you, sorry. Do you want to come in there? Are you fine?
Do you want to carry on?
Or do you want to come in on that? Or do you want to...
I've just got, I have,
Yeah.
I just want to query something with you, Cabinet Secretary. Something you said earlier. You said there's a question coming up. You said there's a question coming up on around binding future governments.
Well, in my briefing, right, I have a briefing that says binding future governments, and that's what I'm talking about. What did you think I was talking about?
Well, how can you know what questions are coming up?
The question on essentially in my briefing. What did you think I was saying?
I don't have no idea. They were your words.
No, I'm just referring to my briefing. That's where I am in terms of my thinking about the bill, because it's the next section of the bill.
Okay, carry on.
So, well, could you explain further the Scottish Government's position on the requirements to lay a report on the intelligibility of a question to be asked in a referendum? And in particular, could you clarify why Scottish ministers have the role of laying a report on the intelligibility of the questions rather than the Electoral Commission itself when the regulations under Section 1 are used to propose a referendum?
Let me be very clear, I'm not against testing of questions, right? There's a sort of indication that I think questions shouldn't be tested. I don't. I think questions should be tested. This relates, and Convener, you said earlier you didn't want to talk about individual examples of independence or whatever, but I'm going to have to on this occasion because it relates to that question. I think there is a category of question which is extremely important, which is a question that is not, I think in the Law Society's words, an old question, but a current question. And the question, in my thinking, and this is, I'm happy to discuss this, in my thinking, the question that was asked in 2014 remains a current question. It's a question that was approved in 2013 by the election government. In fact, the question as it is phrased now was not the question that the Scottish Government put in for testing, which is quite important to remember that. There was a change to that question as a result of testing, and the Scottish Government accepted that, and that was a question that was in there. That question was used up until 2014 in every opinion poll, and it has been used since then in over 50 opinion polls on independence. I think, I'm told by those who know these things, it's only not been used. I think there's 11 months out of the last 40 that it hasn't been used. So I think there is an issue of clarity and consistency. If a question is current and is in current usage, then why would you change it? It would be very confusing to change it. That doesn't mean that if a question, a new referendum is recommended on another subject, for example, I don't want to labour this point on bins, that there would have to be a testing of that question. There's no question about that. But I do think in this case there is a specific example of a current question which I think is well understood and in common parlance.
Okay, I understand what you're saying, and I'm not necessarily disagreeing with that. I do get what you're saying, but as we all know, absolutely nothing stays the same, and I think especially in politics, nothing stays the same. So if the question is current in 2014 and you're telling me it's still current in 2019, I don't really see how you can then argue, well, that therefore is a current question and it will apply in 2025. Well,
I'm not arguing that it should apply in 2025. I'm applying it should apply in 2020, which I think is the First Minister's chosen date. I think nothing has changed in those circumstances. If there is a change in language or a change in usage, then of course it should be considered, but it's still being used. It's still being used, and it's still producing a result that is broadly consistent. I just would find it very difficult to understand why you would change that question.
Yeah,
There therefore has to be, I suppose what I'm saying, is there has to be just as we've said there are different categories of referenda, there are different categories of questions. I don't want to unnecessarily complicate this for the committee or for myself, frankly, but just as there are different categories of referenda, there may be different categories of questions. And in this case, a question which is current, on a major constitutional issue, I think you would tangle with it, with some reluctance.
I'm not suggesting you should tangle with it, but what I'm trying to get my head around is why we're trying to create this referendum bill based on a current question, why we're still debating this. And I just think surely it would be more simple and a simple solution just to follow the recommendations of both the Electoral Commission and the Law Society and just basically require that a question must be assessed and the assessment to be put before the Parliament regardless of when that question was examined before.
Because I disagree with that. I think that that would lead to endless repetition. There is a clarity here which I think should be stuck with. Now, it's a disagreement. I think if you've got a question that's still being used, it's used on a monthly basis, then I think, frankly, it's tautologous to say, oh, we better examine that again. If you've got a fresh question, new subject, of course you start fresh. So, there is no such thing, as a question that would last forever. But equally, you have to define whether a question is current or not current. And there is a current question.
And what we're trying to do,
The question that Alison Harris is asking, it's whether or not you think that the question is appropriate. Isn't it better to put that to an independent body, the Electoral Commission in this case, for them to make a ruling or a recommendation? Because we'll all come at certainly constitutional matters from different standpoints.
Yes, but I don't actually think that applies to every question. It applies to new questions. This is not a new question. This is a current question. It's still being asked. It's been asked, just to repeat myself, every month to 11 out of the last 5. I can see you're as tired of that statistic as I am, convener. But that is the truth. So I can't see why you would suddenly decide, oh, we better brush this one down and have it tested again. It's still there. It's still being asked. It's current.
I'm trying to say, and maybe I'm obviously not explaining myself terribly well to you here, but I thought this referendum bill that we're looking to propose was not really a referendum bill about independence. I thought it was a referendum bill to cover bins on one hand, to constitution on the other. It's to cover everything. So therefore, in the light of that, I really can't understand how you're going back to this saying, well, it's clarity, consistency, it's the same question it's being asked. That question that was asked in 2014 should actually be, in my view, irrelevant to this bill. We should surely be making this bill watertight going forward and have open and honesty. And I really don't see why you don't want to go back to
not trying to be closed or dishonest.
No.
I'm trying to make a point, as I've made earlier, there are different types of referenda. By definition, if there are different types of referenda, there are different types of questions. And you can have a question that is old, out of use, archaic, needs to be changed. You can have a question that is current. You can have a question that is new. So I'm making a series of definitions there, just as I think with the agreement of the committee, also indicating there are different types of referenda. Now, we can debate this, but they are, I think it's a logically consistent position.
Well, I thank you for your answer, but I still go back to what I said before.
You finished? Mary, you want in?
Thank you. Can I ask just a tiny follow-up question on that? If the political makeup of this Parliament changed, would they still be tied to the wording of the question in this referendum?
No, not necessarily, because they could come along and say, we want to test a different question, right? And they'll be entitled to do so. I'm saying that I think if they did so, they would be going against a current definition, a current question, a question that exists, that is continuing to be used. But I can't bind anybody. If there is a different government, they might take a different view. But the view I'm taking is there is a current question, which would apply no matter what. Suppose there had been a referendum in 2017 on something, right? And that question had been asked in a certain way. Well, actually, let's take the EU. I'm trying to avoid the word Brexit in this meeting, but I've suddenly fallen into that trap. Suppose you took, the 2016 EU referendum, and the question that was in there, and you decided to rerun the referendum, not on the basis of, do you believe in hard Brexit or no-deal Brexit or no Brexit at all, but rerun the referendum. I think there would be a reasonable argument to be had that because that question had been asked in the terms of leave and remain, because you actually had that question continuing to be asked in opinion polls, that if you are wanting to do the same thing, you would ask the same question. I think it's a reasonable argument. I'm not saying we're going to agree on it, but I think it's a reasonable argument.
Sorry, Mary, I interrupted you there. Sorry, apologise.
Marion.
Sorry, on you go. Sorry, Mary, on you go.
Yes.
But then if there is confidence that the question is in, as you say, that the current parlance, it's a current question, allowing that question to be subject to the scrutiny of the Law Commission, the Electoral Commission, whoever, if it is in such common parlance, they would more than likely come back and say, that's the correct question. So why not allow that scrutiny to take place?
Well, I would want to know what the alternatives would be. There's nobody I've seen has suggested a rational alternative to this. It's a current question. It's in place. Whereas if you have a new referendum, there will be a number of suggestions. The example I would use is what happened in 2013. We as a government, put something in and the Commission came back and said, we think this is better. So there's an alternative. So, I think there are different categories of questions as there are different categories of referenda. And therefore, while I'm very happy to have the discussion, that remains my view.
Thank you.
Could I just, ask one final? Oh, sorry, you go.
I've got to let Tom in because he's been waiting patiently. So,
thank you. Just a very brief question, Cabinet Secretary. Would it be correct in presuming that where a draft instrument of an SSI, indeed a piece of primary legislation being considered, it would be perfectly acceptable for a committee to solicit evidence, if not a full-scale consultation, from the Electoral Commission, and the Electoral Commission could offer a preliminary view in that regard? Yeah. So there's nothing, and would it be correct in understanding nothing it would bar the Electoral Commission from offering their view, unsolicited or not?
I entirely agree. I just think that the reality is we have in this instance a question which exists and which is used. I think it's very strange to say let's have another question. But of course anybody can give their view on it, and I'm not trying to be difficult about this. It just seems to be a rational position to hold.
You got anything else to ask, Tom?
No, I'm fine, thank you.
No, not you. You want to come back?
Well, I just really wanted to say, to ask you, would you say that it's a fair comment to say that all referenda, is a referenda the correct word, they really stand alone? So with regard to the questions, surely each individual, it's not a continuation of a referenda. The question is there, it stands, you move on to the next referendum. So I don't understand why, why you're still wanting to keep using the same question and also failing to want to include the Electoral Commission and the Law Society and go back to them, so that the question can be re-put.
What the Law Society has a view in this. They would not be a statutory body to do it. The statutory the body would be the Election Commission.
Okay, apologise. Okay.
I think it's not tabula rasa. Nobody can say that never took place. Particularly, and I think my point is, in response to that, the question is still being asked. So you can't say it's entirely separate. The question is asked in opinion polls and has only not been asked 11 times in the last 40 months. I just made my point.
Okay, you've made your point. Any other questions before we? No. So just one last one from me. I mean, it kind of follows on from what we've just been talking about. It's the government's position that it's not appropriate to bind future governments to only making modifications recommended by the Electoral Commission. Could you explain, why that is?
I think it relates to a fairly important constitutional point. In the end, governments make decisions, and the Election Commission is not a government. It should be treated with the greatest respect, and all its recommendations should be very carefully listened to. In addition, those recommendations should be public, and the Parliament should be able to decide upon them. But there is, in the end, a basic point of who makes the final decision and is responsible for that final decision. Now, in this case, in terms of electoral law, that is the Parliament, not any unelected body. So I think it's a basic constitutional point. It, in no sense, if I may use this word in this context, this is the Election Commission. It just says, that's how it is.
Okay. Right. Any further questions? No? Well, I think that has exhausted what we wanted to talk about. I think it was a very, very useful session, and thank you for your
Thank you. I think
Flexibility.
can I just re-emphasise that point, convener? I think there have been, while there have been disagreements and things, I think there is, on our part, certainly a genuine attempt to see if we can find a way to provide this bill with the right delegated powers and the right level of scrutiny. And I'm very encouraged by that because I think we can probably do it.
And that, of course, is our role.
Good. Thank you for it.
Thank you very much, and I'll
Thank you.
move the meeting into private.